All right, so it looks like we have a lot of people that are joining on as I speak here, so we'll just get started. Thank you all for joining us. I am going to send it over to Dave DeBoer, who is going to present on Mutual of Omaha's behalf. If you have any questions, we're not going to do a question and answer at the end, but you are more than welcome to give me a call after the webinar. My phone number is 415-369-9990. Also, Bob Burton is our advanced planner, and he's happy to answer any of your questions as well. And his extension is 116. You can also reach him at bob@pravada.com as well. So, Dave, if you want to get started.
Thanks, Michelle. I appreciate everybody taking time out of their schedule to be here today. I know you have other things going on, and hopefully we'll provide you with some information that might be of use to you. Today we're going to talk about some issues devoted to non-traditional estate planning, and I hope some of you have had an opportunity to visit with some of your clients about the estate planning market and some of the topics that we'll touch on today. But there's an avenue that maybe is a little bit left untouched in the estate planning market, and it has to do with what you might call non-traditional estate plans. And by that, we're going to use the term non-traditional to include second marriages, single parents, single individuals for whatever reason, and then same-sex couples obviously fall into this blanket as well. And so when we're dealing with these individuals, we have some issues that I think are common to all of the groups. And we're going to touch on these issues today real briefly. The issue of documentation, what kind of documents will be used, and certainly one of the documents that's important is the area of trusts, and we'll visit just a few minutes on that. We're going to talk about settlement costs and transfer taxes and how that pertains to this unique set of estate planning situations. We're going to talk about property ownership, how that's impacted, and finally we're going to touch real briefly on insurance ownership and beneficiary designations. And again, we maybe get a little bit simplistic on our estate planning when we're dealing with traditional families, but the non-traditional unit really brings forth some ideas and issues that are unique, and we're going to touch real briefly on that. Again, we're going to present an awful lot of information in a 15 to 20 minute period, so feel free to contact Mikkel or Bob after the call is over if you have any questions or need any further information. First of all, let's talk about the will. That's usually the cornerstone in most estate situations, most estate plans, is the will document. But because of the unique situation, the family situation now, we may not have a traditional will in place. A lot of times we'll have what's called an I love you will. Husband leaves everything to the wife, wife leaves everything to the husband. If both spouses are gone, the remainder passes to children. Well, if we don't have a spouse right now, it may be difficult to take advantage of some tax laws, and so the will document needs to reflect where we would like assets to go. We need to make sure that in the situation where there may not be a surviving spouse, that the personal representative is chosen with some care. That's the person or entity that's going to be making some decisions on behalf of the deceased party. So we need to make sure that individual knows the situation. Guardian for children is extremely important, especially with minor children. Who's going to provide for that individual? Who's going to look after those minor children and make decisions on their behalf? The same can be said for any special needs children that are out there. That would extend maybe beyond the age of majority and can in time, in certain situations, last for the lifetime of the special needs child. So it can be a very important designation. The next bullet point is talking about elective share, which may or may not be right to choose either the bequest that's given to them under the will document, or they're given the right to take what's called the elective share, and that's the intestate share that the state of residence has allowed the surviving spouse to have. And now the spouse has a choice, and typically they'll take the larger of the two options that are available. If you're in a state or in a situation where you are not technically married, that's not an option. And so typically the elective share doesn't pertain to a non-spouse. Where it becomes an issue is where you have same-sex marriages being, I guess, granted legal status in a certain state, and how does that impact the will document as opposed to any federal taxation calculations. If you're in a state where marriage with same-sex couples is legalized or recognized, the will document can in fact pass assets to a quote-unquote surviving spouse. Unfortunately, federal law doesn't always match the state law, and so for federal estate taxation treatment, the federal government does not recognize same-sex marriages under the Defense of Marriage Act that was passed a few years ago. So we don't have the same tax advantages for a same-sex couple under federal law that we would under state law. The real important thing to talk about with the will document is to make sure that the provisions of that document is coordinated with other documents, whether it be a trust, a beneficiary designation, or whatever. The next document I want to touch on real briefly is a power of attorney. This grants the ability for someone to make decisions on behalf of the client, and when that document becomes effective pertains to the wording of the document. Typically it might be when the individual may not have the ability to make decisions on their own behalf, and that's usually certified by a doctor's certificate. But it's real important in the case of a non-traditional estate plan is to designate who is going to have that power, whether it be a family member, whether it be a person that cohabitates with the insured, or in this case the client. And is there any potential for conflict? If you have a same-sex partner that may be not on great terms with the rest of the family, does that create a conflict in the issuance of a power of attorney? And was anyone else told about the power? Who has the power? And it's real important at the time that it's needed that we have the ability to locate those individuals and they can actually act on behalf of our client. The next document is a living will or a medical directive. Living will is typically that document that allows for the cessation of any life-saving measures. And the medical directive is much like a power of attorney, only it pertains to medical decisions that are being made. And again, it's real important if there's not a surviving spouse, if it's a single family, a single parent, who has the power to make these decisions on behalf of the client. And in same-sex situations, again, will that create any conflict by having somebody else make those decisions? And it has that ability to make those decisions been communicated. The last document I want to touch on real quickly is the issue of trust. And again, like everything else, the components of the trust are extremely important in non-traditional settings as well as traditional settings. Who is going to be the trustee is paramount of importance. Who is going to make those decisions and manage the assets in that trust? If it's a revocable trust, have the assets actually been transferred into the trust? Typically that's something that's forgotten about. And will anyone else other than the grantor of that trust be affected or be supported by that? we need to make sure that those people are accounted for. In an irrevocable trust, again, typically larger estates have this type of trust. It's for estate tax planning purposes, and because there's not a traditional spouse involved in the estate, these can be extremely important. If you have a second marriage and you have children from a prior marriage of maybe both spouses, trusts can be extremely important in protecting the rights of children from previous marriages, from existing marriages. Adopted children can play a component of this. So trusts are an extremely valuable part of this estate plan.